I'm going to be talking to Drew Yewchuk, who is a staff lawyer at the Public Interest Law Clinic, University of Calgary, and author of the ABLAWG post, Abandonment and Reclamation Obligations, Builders' Liens, and Municipal Taxes in Oil and Gas Bankruptcy Proceedings. So welcome to the interview, Drew.
Thanks for having me on again.
Now, I probably put half of the audience to sleep already with that introduction, but in fact, this is a very, very interesting decision by the Court of Appeal, and it has all sorts of implications for the Alberta oil patch and people who do business with it. So why don't you start with giving us an overview of your post, please?
Sure. So the company in question is Manatock. And so this bankruptcy goes way back to the Redwater era. When Redwater went bankrupt, that case went to the Queen's Bench, the Court of Appeal, up to the Supreme Court. So Manatock goes bankrupt in February 2018, or enters bankruptcy in 2018. And then the bankruptcy process goes on, and the transaction, the major transaction in question here to a company called Persist happens in early to mid 2019, not actually completing to the end of 2019, because they need the AER license transfers after they work out the details of the sale itself. So this is still a tail end of Redwater, and the Court of Appeal decision discusses the Redwater Supreme Court case and interprets it, and also a particular section of the Bankruptcy and Insolvency Act, 14.06.
So the issue here is that the obligation, environmental liabilities take first precedent when there's a bank's bankruptcy. They get paid first.
Yeah, and that was a key question in Redwater itself, but focused there on between the AER and the Orphan Well Association as opposed to banks and lenders. In this one, it is between the AER and OWA and between lien holders who had done work for the oil and gas company before entering bankruptcy, and indirectly several rural municipalities who intervened in the case.
Now, before we get into some of the meat and potatoes of your post, something you said or you wrote near the end of the post caught my attention, and that is that this is a good case study in the limited power of litigation and courts to fix large policy problems. What did you mean by that?
So that relates directly to the work of the clinic in the Public Interest Law Clinic. There's maybe a common myth that large policy problems are solved just by going to court. And one of the conclusions drawn out of the literature on public interest law is that that's rarely the case, if ever. Some of the most famous ones out of the US from the Civil Rights era was Brown and Board of Education. But that case was followed by a long period of enforcement and legislation change at the federal levels, fights with the state governments. It was the beginning of a long process of getting that policy actually changed. And Redwater, though not comparable to Brown v. Board of Education in a lot of ways, is something like that. It marks an attempt to do something about abandonment and reclamation obligations, but the court can't rewrite policy. They interpreted one section of law and solved one constitutional question. And there's a lot of work for the provincial government in Alberta and for the federal government, who controls the Bankruptcy and Insolvency Act, to get environmental liabilities in bankruptcy as a broad issue solved.
And to give viewers a scale of the problem, I forget how many wells there currently are in the Orphan Well Association. It's thousands, but my understanding is that abandoned wells are hundreds of thousands.
Those numbers are readily available on the AER website now. They put up a new feature which shows the list. I don't remember the number of abandoned. It's
don't worry about it. I'll put the link up in the YouTube description, so that's okay. But anyway, it's a lot of wells, and it's a big environmental liabilities for oil and gas is a multi-billion-dollar problem. Correct?
Yes. And the one number I do remember offhand is that the most recent ones for inactive wells that are no longer in use but haven't been permanently sealed, is about 90,000. And it's been more or less steady at 90,000 for about 4 years. Okay.
So what other kinds of issues got dealt with? For instance, the municipalities. It sounds like there are a lot of municipalities are owed hundreds of millions of dollars, and they're just going to be out of luck.
Yes, they're in a rough spot. So they intervened in Manatock, which is worth a few $1,000,000 to several rural municipalities, because they're worried about another company coming down the line, Trident. And I don't know how much Trident owed the rural municipalities, but they were concerned enough about the precedent that would be set here that they got engaged now before Trident came up. So this is not great for them. This is very likely to mean that the OWA and the AER are going to take definitely before the lien holders, almost certainly before the rural municipalities. And other forms of lenders, I guess banks specifically, and people who lend money to the oil and gas company can change the structure of their transactions to try to protect themselves. Rural municipalities and the landowners who might have wells and pipelines on their land don't have that option. Under Alberta law, if the company owns the rights to the oil under the land, they're going to get access. So there's very little the rural municipalities can do to protect themselves.
So let me review this as a layperson. The AER grants a license to a company to drill on a farmer's land. And the company then has the right to go to build a road onto that well site and take that land out of production, let's say, and there's nothing the farmer can do about it. But the farmer is supposed to be compensated. But now we're hearing a lot of stories about how the oil companies just walking away from those obligations, and landowners, farmers are not being compensated. Is that correct?
That's correct. The first detail is that the company needs to have the rights to the oil under the ground, the subsurface rights, which get separated in Alberta, which is unusual as a jurisdiction for doing that. But other than that, everything is correct right up to the end. And then sometimes the companies aren't walking away. They're continuing to operate, but no longer paying. Or they are paying a reduced rate. They're sending letters to landowners saying, we can't afford to pay you, the land rent. We'll pay you 1/4 and we'll start paying normally when the market is good. And landlords have been, not landlords, rural municipalities and landowners who have these problems have been dealing with this for quite a few years.
And yet we've now, since, I don't know, the last year or so, we've had really good oil prices, and presumably the market has improved, and it seems like this is still a problem.
Yes, and sort of to my surprise, in one of the earlier blogs I wrote months back now about Bill 77 and the attempt to give rural municipalities the ability to place their own liens on oil and gas assets, I said that the problem was probably going to get smaller for a while prices got better. But it doesn't look like that has happened, or has happened to the degree I expected.
Is this a case where, an oil company that's got, a team of lawyers and can afford to just says, we've kind of discovered that we don't have to pay you. And so, come and get us if you want. Take us to Mr. Farmer, the individual, sure, take us to court. We'll just drag it out for a long time and run up your legal fees, and maybe you'll get it, maybe you won't. Is that what we're looking at?
Yes, I would say that seems to be part of it. And part of it is the oil and gas industry counting on their access to the Alberta government. And so what makes this, to a person solely interested in political science, fascinating is that there's a fight coming and already ongoing between the oil and gas companies and rural municipalities, which are two huge supporters for the current Alberta government. So that creates an awkward position in Alberta politics, and I have no idea where it will go.
Yeah, there doesn't seem to be any momentum, any political will to resolve the conflict.
Yeah, I would say that seems about right. Bill 77 was a very small change, and I don't think it really affected anything. You can't collect from these companies by putting liens on the assets because most of the assets aren't valuable. That's the core problem. That's why they're stopping their payments. The assets aren't worth that much to them anymore. Alberta is running, not out, but it's starting to run a little low on conventional oil and gas. And this is a very aging industry. So we're seeing a lot of the impacts of that. And I'm not convinced Alberta is well positioned or prepared for it at all.
Well, Drew, thank you very much for this. Really appreciate it.
Thanks. Nice talking to you.